Welcome to the Listen to This Bull Live show. This is the show where we get to. I'm going to turn down this mic because, wow, that's probably a lot better. This is the show where we get to answer your questions live while you ask them to us in the comments. If we don't have a guest on, which we don't today, then we might even pull you onto the show to talk to us a little bit about something that you have a direct interest in or a question in. So today's show is a little bit unique. We don't have a guest. We're going to sit here and we're going to talk as the guests. We're the guests.
There we
So
go.
My name is Matt Mulholland. This is Remington Huggins.
Remington Huggins. It's a big, ticket item that everybody in the state of Georgia specifically has been wanting to know about. And that is the new bill in regards to public adjusters in the state of Georgia. So I'm sure we're going to have a lot of interest about this topic. And we didn't have a guest on purpose because this needs to be discussed.
There's a ton going on with this bill. And there's a lot of questions that everybody has been calling me to ask. And I wanted to make sure that we had everything covered because this has been our lives for a couple weeks now, 3 weeks.
It really has. I've literally put, I'm a business owner with my own law firm. I have put that to the side these last couple of weeks to concentrate on this bill and to put our best foot forward for public adjusters in the state of Georgia.
Well, it's not just about public adjusters. There's a lot in here for contractors and anybody that's in our industry or will be affected by this in some way or other. Ultimately, the policyholders are the ones that we really need to think about when it comes to all of these provisions. Will it affect a policyholder and how will it go about doing that?
So that's right, Matt. And it's really focused in what the whole agenda of the bill is what's best for the policyholder.
Right.
And so we can't lose sight of that. That's for sure.
Opie Waddell, how you doing, bud?
Nice seeing you, Opie. It's been a minute.
I'm going to throw his thing on there so you don't think we just said that out of nowhere because we're not that weird. Maybe a little bit.
And to give a little preference, this is very new. This bill is very new. We will be referencing to the drafted bill that we have in front of us today. So we might not have all the answers, but I can tell you if there's two individuals in the state of Georgia that has a lot of this information to provide to the viewers, it would be Matt and I. And I can confidently say that. But it is new. And Matt, and correct me if I'm wrong, did the bill pass the House today?
It passed today. Just from the House. So it started in the House and it is a bill there, a House bill. And then once it passes through that after several committee votes, then it goes into a waiting period for it to get to the Senate and become a Senate bill. So in the state of Georgia, when it goes from the House to the Senate, it changes bill number. So it's not going to be a House Bill 254 anymore. It'll be SB, Senate Bill, something. We don't know what it's going to be. And that's not going to happen until crossover. And that's when all the bills that originate in the House get sent to the Senate if they pass the House. And all the bills that originate in the Senate that pass the Senate get sent to the House. So crossover will probably occur around the first week of March. It could be a little bit earlier, but most likely it's going to be the first week of March. And things are a little bit shaky on timing for a lot of the stuff that we're going to talk about because everything's just weird from COVID. So the timing is a little bit different than it normally would be.
Matt, you did a great job on us attorneys call that procedural history, where it started and where we're at now. And in every motion and document that we file with the court, especially motions, we give a section that's called procedural history. Did a great job on that, man.
Thank you. I did it without a legal pad.
I got to have my legal pad. That's just, he makes fun of me for that. Everywhere I go, I got a legal pad. So, and the other attorney we had on as well, Wood, he asked him if he had a legal pad and he whipped one right out.
Did. Every attorney has a ton of legal pads, it seems. So, all right, we've got the current version of the bill in front of us. There are edits that were agreed to that are not going to show up until the Senate bill. And we're going to talk about what those are. So when you read this, it isn't it is the most up-to-date version, but it isn't the agreed to full language. There were 5 other edits that we were able to accomplished during that time. So we're going to go through a lot of this in a rather structured way. But ultimately, if you have a question about anything that we say or anything in general about how this would affect you, how it would affect the policyholder, how it would affect the state, where things are headed, what our opinion is, anything, leave a note in the comments. And Olivia's standing by. If she wants to pull anybody on, she can send you guys a link. Otherwise, we'll just answer your comment and go from there. So let's give you a little bit of history of how this was presented to us.
Let's do it.
Myself and Remington are both on the board of GAPIA, the Georgia Association of Public Insurance Adjusters. And late last year, the Department of Insurance reached out to us as someone that this bill would affect and asked for our opinion on it. And we were going through a lot of that to give them a full breakdown of what our opinion of it was and how we could help them word this thing a little bit differently. And then the bill just dropped on us. It just suddenly was legislation, and it had a House bill and it had a number. We didn't expect that. We thought we were going to have our moment to talk to the Department of Insurance.
And this occurred in January.
Yeah, so January. So we didn't expect this to happen. In fact, we started talking to our GAPIA members prior to it dropping to discuss getting lobbyists and things involved. And so we did. We got we had a big membership drive. We almost doubled in size as an organization overnight, which was fantastic. Well done, Jennifer Campbell, who took most of that, by the way. We got a lot of new members, but then the bill just dropped, which is a shame because we were discussing with our new members the fact that we were going to be sitting at the table. We needed to get a lobbyist involved, but we needed to have that moment with the Department of Insurance. And then they dropped the bill on us. And
Right.
Not only drop it, they dropped it on a Wednesday. And then it was being voted on in the subcommittee or on the following Tuesday. That's less than a week. That's very fast.
It was getting
Very
pushed, no doubt.
And there was a little bit more issue. It was, I don't know if it's by design. Well, I actually think there was a miscommunication. I'm going to get to that part of the story. It was written by the Department of Insurance, and it was sponsored by the House Insurance Committee chair. In fact, I had 5 sponsors on the committee, but the main sponsor, which they would call the author, even though he didn't actually write the bill, they call him the author. He is the House Committee chair, the House Insurance Committee chair. So that's 2 big things against anyone that has anything to do with this bill. If a department of the government writes a bill, it's usually fast-tracked. If the House Insurance Committee or whatever committee it is, if it's their chair that sponsors the bill, it's usually fast-tracked. This thing was being fast-tracked. And that was because of the source. Now, when we ended up talking to the Department of Insurance, they were under the impression they had already talked to GAPIA and gotten our approval on the bill. There was someone else involved that may have possibly designated himself as being a part of GAPIA that may have agreed to the language in the bill with the department's assumption that that was GAPIA agreeing to the language in the bill. And so when GAPIA did get involved with them and finally had the meeting, they were a little bit confused and it was a little bit odd. So our relationship with the department was a little rocky there for a second, which we fixed. You know, we are good at dealing with
cleared the air.
Yeah.
And when I say there's meetings, I'm talking meeting after meeting after meeting every single day, meeting with the attorney at the Department of Insurance, expressing our concerns. It was a nonstop, proactive, force, if you will, that we were doing. But I'll let you continue, Matt.
We took a year off our lives in the last 2 weeks at least. My poor wife hasn't seen my face in a while.
This reminded me that I do not want to be in politics. It really does. It really did.
Right?
My gosh.
I know. It's terrible. I need to have a sip of the beer before I finish this story.
I'd rather fight big insurance companies with all the money than deal with this again.
So Right before all this happened, I became the president of Gapia. Merry Christmas. Here's a giant bill that has to do with your entire profession. And oh, you're the president. You get to do some stuff with this. Yay. Um, anyway, so we got our seat at the table. We started working with, or at least alongside, another organization, AAPIA, AAPIA, the American Association of Public Insurance Adjusters. AAPIA. There's GAPIA, the Georgia Association, and AAPIA, American Association.
Right.
I don't think that's how they pronounce it, but that's how I have pronounced it every single time I've said it.
Matt, it's your show. You can do what you want.
I can do whatever I want.
Do whatever you want.
So APIA did have a meeting with the Department of Insurance. It dropped on Wednesday. We met with them on Friday, and we were able to piggyback into their Zoom meeting with the department. And yes, it was via Zoom because of COVID. So there was only a few of us members on there, but we went through the bill, and we had already written a ton as the Board of Gapia throughout December about all the things that we wanted to address. And we got a few things accomplished in that one. And I'm going to go over what all the accomplishments were in a minute, not get into the nitty gritty on this. But we got a few things accomplished that Friday in that meeting. Now, Gapia had already set up, we had our own meeting scheduled for the following Monday. Now, remember, it's being voted on in the subcommittee on Tuesday. So Gapia's meeting with the DOI, the one that we thought we were going to have before the thing dropped, was on Monday before it was voted on in the Senate committee. We went into that meeting, and the Department of Insurance, they weren't as responsive as they were in the Friday meeting, but we still made some headway. And this all really comes back around to the miscommunication that was received. So we didn't make that much headway on that Monday, but we got a little bit. And then there was a subcommittee the next day, and the House Insurance Subcommittee is a small committee of individuals. It's just the committee heads and chairs, or not chairs. I'm new to politics, so I'm going to get some of this wrong, and you're just going to have to deal with it. I'm sorry. I'm learning as I go. So all those, they end up voting on Tuesday, but there was a subcommittee hearing. And
at the Capitol.
Now, we didn't know if we were even going to be in the hearing. It sounded like it was via Zoom only, or possibly that it was, well, we didn't know if we were going to be able to be let in because of COVID. Turns out it was an open hearing. There was just limited space, but you could show up and then sign up on the sheet to speak if you wanted to. So that's what we did. APIA showed up as well. AAA was there. The APA, Doug Quinn, was there as well. So it was Gapia, APIA, AAA, and the APA were all speaking that morning. In the meeting on, I have to be careful with the words that I say because of my position as Gapia. So bear with me as I try to figure out the proper way to say things without getting anybody accidentally in trouble, I guess. That's not really the right word. That night prior to, after our meeting with Gapia on Monday morning, we ended up having an agreement to meet with the Department of Insurance on the language right after the subcommittee hearing. So when we went into the subcommittee hearing, it was not a heated exchange from Gapia. It was a very simple, we want to continue working on the language with the Department of Insurance. Because we want to be able to support the bill, we acknowledge and support the intent of the bill, and we'll get into what that is in a minute. So we spoke about that. The Department of Insurance attorney Greg Conley spoke at that hearing before anybody else. They had a witness that got up and spoke that had been screwed by her insurance company, and then hired a public adjuster, and then got screwed by her public adjuster too. So double whammy. It was terrible for her. I'm not going to say any more about that. Then AAA got up and spoke, and Mike Lindhurst, who's always so eloquent, got up and spoke quite a bit. Doug Quinn got up and spoke on behalf of the APA. There were a few other people that got up and spoke, and then the Department of Insurance attorney Greg Conley came back up when the committee requested that he come back up and answer some questions. So that's roughly what happened at the subcommittee hearing. And then Gapia, a few of us with somebody from Appia also got into another meeting with the Department of Insurance afterwards, where we made a lot of headway. And that additional headway, it's not in this yet, but it has been promised to be in the Senate bill when it becomes a Senate bill. And I believe that AAA also got another meeting with the department afterwards. And from what I understand, they ended up discussing some of the same language that we were discussing. That's a little bit confusing in this. So I think that's probably good enough history.
I think you did a great job on the procedural history. It really was a big, massive, proactive front from a lot of different directions and a lot of different organizations. And yeah, I'm ready to dive into the bill and kind of discuss what was proposed, what was agreed upon, and the changes that were made.
I am not a natural politician. It is true. I don't lie very well. Not that I needed to.
Hey, you did a fantastic job.
Holding back information feels an awful lot like lying sometimes. I'm not a big fan.
I hear you. I do not want to play politics. That was definitely something that came to my mind and reminded me.
It is currently a House bill. It is House Bill 254.
That could change, though.
It will change because it just passed the House as 254. After it goes through crossover and becomes a Senate bill, it'll be an SB, and we don't know what the number is just yet.
Yep.
And that will be early March. So let's talk about the intent of the bill first, maybe.
Let's do it.
What the Department of Insurance described as their reason for creating this. And then some of the language that is in here, what we were able to work with them on to fix some of the problems and holes that we saw. And then we can start getting some questions from you guys directly. So the intent of the bill is, this is a public adjuster bill. It is how licensure of public adjusters is dealt with, advertisements, financial responsibility requirements, contractual requirements, whether or not there can be relationships between contractors and public adjusters.
Which is a conflict of interest, is what they pointed out.
All of these things stemmed from what the department called bad actors of the public adjustment community that were causing some issues. That person that got up and spoke at the subcommittee hearing was one of the victims of one of those bad actors. And there definitely is a little bit of a lax regulation as far as public adjusters go in the state of Georgia. So I think that this was designed to just tighten up some of those things so that the department could actually go after the bad actors. So that was their intent. The intent was to
protect the policyholder.
So we agree with that intent, 100%. Because it's our profession, we get a little bit nervous when there is something like this on the table. But we were looking at it like this. We had an opportunity to work with the Department of Insurance to hand in hand develop something that was good for the policyholders, but also doesn't hurt the public adjuster profession and ultimately leaves the state in a better situation than it was. Now, we've worked with them quite a bit on the language here, and it may not be perfect, but the intent is still there, and the intent is okay. I believe in the intent. It definitely needs to happen. There's 100%. Definitely some bad actors that need to be taken care of, and this does close up those loopholes. And we're not done. This is just past the House really fast. and now it's going to be in the Senate, and it's going to take a while there. So we've got a little bit of a breather. I am actually getting more than 4 hours of sleep, which is good. Being able to get caught back up on my files again, that was a little bit rough. But
hopefully this is the last time I have to look at bill language and how to modify bill language during the Super Bowl. That's all I'm saying. Hopefully it's the last time I ever
you
do
watched the Super Bowl?
that. I tried.
Wow.
I
I have
tried.
no idea what happened to the Super Bowl. I have since
Brady won.
written every regulation in Georgia that pertains to property, just so that I understand what the problems in it are and where the holes are, so we can present that to the Department of Insurance soon. But that's a whole nother topic.
Yep.
Many hours of probably worthless stuff. All right. So what is in this thing? This is really comes down to 6 categories of stuff. Allowable types of remuneration, how they can get paid and what's allowed for public adjusters. Proof of financial responsibility and any additional responsibility required for public adjusters for financial responsibility. Record keeping requirements, new record keeping requirements. This says certain consumer protections, but ultimately that comes down to conduct of public adjusters. Advertising requirements for public adjusters. Several more prohibited acts.
Fee cap restrictions.
There's some repeal of conflicting laws that is in every single bill. So that's the rough categories that are involved. So let's start at the top there. Allowable types of remuneration, I'm actually going to save till last because I think that is the thing that most of you are probably watching for. The relationship between contractors and public adjusters really comes into play into that section. So forgive me. I'm going to leave that last because I think you'll have the most questions. And if I get through the other things first, it'll be a little bit easier to get to more questions at the end. So provide proof of financial responsibility. So in the state of Georgia, there are already laws that you have to have a bond of a certain amount. And that bond basically says that you are financially responsible for a certain amount of funds that the insurance company is basically vouching for you. That's what a bond is for. So the bond requirement and the licensure requirement, you have to take a test and all this. This is all the normal requirements. This bill allows the Department of Insurance to determine if there is any, or if they want to add any additional financial responsibility requirements individually to people. One of the things that we actually worked on with that was it said that you shall provide proof of financial responsibility, and then it listed all the ways in which they could increase that. And we were able to work with them, and the new language is may, at the commissioner's discretion, be required to provide financial responsibility with your renewal documents whenever you renew your license, whenever you get a license. So the idea for the department was that they wanted to be able to individually, if necessary, impose additional financial requirements on individuals. So if you are acting badly or you have a lot of complaints against you, they may require additional amounts. Or it could be that maybe they know that you're handling massive claims and they want you to have more financial responsibility in place, whatever that might be. Insurance could be. It's very vague.
And just to be clear, what I will try to do is after Matt goes through each one of these sections is give you just the big picture. And what this specific section does is it provides the power to the Department of Insurance to enforce specific restrictions or financial responsibility on specific individuals in the state of Georgia. That's what it does. And I know E&O insurance is one of those elements that was discussed on making an individual have if the Department of Insurance deems necessary.
I was just reading Gordie Powell's message that Olivia popped up real quick. Yeah, it is. The intent of the bill is to be consumer protection, and for that, it it's doing its job. There is definitely some protections built into this. So it is not a horrible, terrible bill.
And you address that, Matt, though, in the front.
Yeah.
This whole bill, the whole concept of this bill is for policyholder protection.
Yeah,
All right,
so
that's what it's for.
So Gordy, and actually Gordy would know, he deals with, or has dealt with this recently with a new administration of some kind for, I think it's for biohazard type claims, things like that. That industry, that's what Gordy is into. He does, if there is suicide or something like that, the property damage that exists after that, that's what Gordy deals with. It's really interesting claims, actually. They're a little bit smaller, so I haven't gotten involved in very many of them, but they were really cool to work with. Anyway, I can geek out about that a little bit later. All right, so there's that possibility. Now, look, here's how it works. You have these statutes, you know, in Georgia, that is Title Code 33 for the Department of Insurance. All of the Title Code 33 is what the Department of Insurance deals with. All of those statutes are laws. They can only be changed by legislation. And then you have regulations, which is Chapter 120 for the insurance commissioner. Anything that he has promulgation authority over, given to him by the statutes, allows him to make changes regulatorily just by rewriting the regulations and then posting it. And he can hold a hearing, but it will eventually it becomes the rule, the law of the land 45 days later, I think. So the statutes are meant to be broader in order for the regulations to really dig down narrowly into what those statutes mean and how the department is going to use that from a direct standpoint. This is what the department's doing here. This is what the department interprets this as and how he's going to apply it. So this is a law that will be in the statute. So these are going to be a little bit vague and a little bit broad. And that doesn't necessarily mean that it's going to be used that way. It just means that it does open things up to interpretation for the Department of Insurance to interpret.
That's exactly right. And I believe it's 33, 23, 43 is the actual statute itself that we're discussing right now. And what Matt is talking about is the regulations that follow that are more specific, that have more content on exactly what you can and you cannot do. And people who practice here in the state of Georgia, whether it's a PA contractor, I don't know if contractors practicing, but as a contractor or an attorney, for instance, the automobile regulations, right? They're more specific. Within 45 days, there must be a coverage letter, things like that, that will happen down the road when it comes to this actual bill that is that just was passed today.
Okay, so we'll move on. So there was, what did we get to? Proof of additional financial responsibility requirements. So that could be placed individually. Moving on. What was the other section headers? All right, this is a big one. They imposed a fee cap on public adjusters in this bill, and it originally started at 10% across the board was what was in here. When it became a House bill, it was changed to 10% for residential claims and 33.3% for commercial claims. I know it's backwards. Well, in our first meeting with the Department of Insurance, we were able to secure 33.3% across the board. They are very adamant that there is a fee cap there. So this is a fee cap that I think most people could live with, but that's what it is now. Or
certainly, but
that is currently in this version that has been passed. So it's not additional language that has to be added in once it's on the Senate bill.
I really want to emphasize what Matt is saying is when we first got this bill that was drafted, it was a 10% fee cap across the board.
That's right. No. Well, yeah, drafted. Yeah. So before it became a House bill, when we got it in December to look it over, that's what it said. So
10% across the board.
When the thing dropped, That was the only difference on there, was that it said 10% residential, 33.3% commercial, which we were all very surprised about. Where did that come from?
And all the organizations and individuals that were proactive on this bill got it from 10% across the board to 33 1/3 across the board. So I want to really emphasize that is a big, tremendous improvement.
It was. And a lot of that had to do with APPIA's involvement, actually. So I want to give credit where it's due. That was
Absolutely.
a big, that meeting between GAPIA and APPIA had a lot to do with that one.
And honestly, Matt, I've handled thousands and thousands of property insurance claims, and I can't think of one time where, it's exceeded 33 anyway in the past. But
Well, I'm sure that there are some.
I'm not saying there isn't. I'm just saying I haven't seen it.
Maybe. Okay, so moving on. So that was the fee cap. What else we got? Payment authorization. Who can sign for on behalf of the insured is something that's in here. So let's scroll over to that section. We probably should have wrote down what the sections were. Oh, it's a very long bill.
There's a question from,
Read it out to me.
I don't understand this exclusion in my E&O insurance. Doesn't this sound like it excludes everything I do? This policy does not apply to, and we shall have no obligation to pay any damages, claim expenses, or supplemental payments for any claim based upon or arising out of any actual or alleged performance or failure to perform public adjusting services.
I'm kind of confused on the question because I don't know if there's an exclusion. It's actually an enforcement of particular E&O insurance by the department if they deem necessary on a specific licensed individual in the state of Georgia. I don't think it's an exclusion. And also, I want to reiterate what I said earlier that because I had some text messages come through with PAs that I work with that sometimes the fee is higher than that 33, but once it gets to me, there is some type of agreement where the fee lowers from that. So I do want to say that.
We set it at a bar that we thought everybody, most people would be
Exactly.
acceptable.
But I do not understand. It's not an exclusion. Let me be clear here. It's
It
just
sounds like it's a negligence issue. If you're acting in negligence, then or found to be negligent, then that's when your E&O wouldn't kick in. Is that what that is? If you're found to be at fault, is that what that is?
that has nothing to do with the bill.
We don't deal with
That's
liability
specific, yeah.
insurance
Right.
as public adjusters. So
That's specific policy.
yeah,
E&O
thanks,
insurance.
Chad. Jeez, we got a lot to go over here, bud.
Chad, nice seeing you, bud.
All right, you know what? I'm gonna do this differently. Instead of going through the categories, I'm just gonna scroll through because we
go.
got highlighted things. I think it's a little bit.
Let's just
easier.
go on. Hey, we're politicians now. We got to go off the cuff.
Right. Okay. So there are some new languages in different parts of this. A lot of the bill is old language that already currently exists. So some of this really doesn't make much difference. But you can't hold yourself out to be a public adjuster without being a licensed public adjuster. Did you see that just fall off my face?
I did. And also there was some language where they want to make sure that you do your job as a public adjuster, that you get a file, that you actually attempt to adjust the claim itself prior to handing it off to an attorney to litigate the file. I don't, and honestly, my opinion, I don't think that's an issue here in Georgia. I think it's more of a sister state issue, but that is, you must actually have intent to adjust the claim on behalf of that policyholder, which I think it's a good, I don't mind it at all.
It goes hand in hand with another section that's in here. The public adjuster contract is, by the way, the PA contract is going to have to be approved by the commission before you can use it. So it's very similar to the state of Texas, where they are going to create a statewide contract. And if you want to make any difference or changes to that as your company, there's the minimum requirements, but then you'd have to send it off for the commissioner's office to approve it before you could use it. But hand in hand with that is right now you have the ability to actually write a public adjuster contract where you can also in the same contract write that you can act as an appraiser or you can act in other roles, assignment of benefits, all these things. So part of this bill is that the public adjuster contract can only be for acting as a public adjuster. So any language that purports to allow you to change your role in a claim, you can't do that with the new thing. And I think that ties into the whole intent. That if you go into a contract as a public adjuster intending to actually be an appraiser, that's a very different thing than having a public adjuster contract. So I know in other states where attorney's fees get paid, there are a lot of PAs that probably hand things off to an attorney pretty quickly because it doesn't hurt the policyholder. But they may not have the intent to act as a public adjuster. They're more of a runner for an attorney. And this definitely prevents that from happening. But ultimately, I think that this really comes down to acting as a PA instead of acting as a PA or other things. If you always intended to only be an appraiser, for example, then this intent to adjust is a big deal. Do you think that the intent to adjust revision helps lay the foundation for a cost balancing bill? No PAs being attorneys, sales reps, like in certain other states where that is the biggest complaint about a fee shift.
Yeah, I think that certainly is what they were preventing is for a public adjuster or a public adjusting firm just to be a springboard into an attorney's lap. Just sign up claims, send them over to an attorney. They actually want you to adjust the claim, whether, and they weren't specific about it either, though. I mean, it's not saying, hey, there must be an estimate on the file, things like that there wasn't specifics. But you have to have, like I said, quote unquote, the intent. And Joshua, I think you and I are thinking on the same terms of what sister state, they're preventing
I think
this.
we can name states.
Yeah, it's Florida.
It's Florida.
Yeah, Florida.
It's not like we're naming an insurance carrier. It's
Hey.
a whole state.
Hey,
Is this state going to sue us?
no. And I said sister state, which is true.
That makes it very feminine too.
Yes. We're talking
Which is
about the state
odd
of Florida.
for the state of Florida because of its shape.
I'm not gonna go down that
You
path.
probably shouldn't go down that route. So here's that one. It purports to allow the public adjuster to act in multiple capacities or identifies the public adjuster as also being a contractor, appraiser, or other position. And then down here, no public adjuster shall enter a contract with the insured or collect a commission without having the intent to actually perform services customarily provided by a public adjuster for the insured. So those two languages, they're in the same section. That's all it has to do with contracts. So then it gets into the fees and how a public adjuster can charge. And here's the 33% language. A public adjuster may not charge the insured an unreasonable fee, and the total commission received shall not exceed 33.3% of the amount of the insurance settlement of the claim. So that was a APIA addition. They like to use the word unreasonable in other states instead of you have to charge only a reasonable fee. That's too much interpretation. But by saying that you cannot charge an unreasonable fee gives the commissioner a little bit more authority over it.
And quote me if I'm wrong too, since we're in the aspect of contracts here, that now your contract has to be approved by the DOI before you start using that contract. However, the DOI will put out is it a blanket contract for a PA? And then if you add any language to it, it must be approved.
I think it'd be easier to call it a template.
A template, blanket,
Just like in
want.
Texas.
Yeah.
Yeah. So that's what they have there. So they have a Texas public adjuster contract. It's very standard, very basic, but you can add stuff to it as long as you have that same language in it. You can put more on it. You just have to get it approved before you can use it if you do that. An adjuster shall not accept any payment that violates the provisions of this code section. All right. So here is the signing of insurance checks. A public adjuster may sign or endorse a payment draft or check issued on behalf of an insured if authorized in writing by each insured payee, only if such writing endorsement meets the following criteria. This was not there in the original bill. What it used to say was that notwithstanding any agreement between the insured and the public adjuster, no public adjuster shall endorse or authorize the payment on behalf of the insured. We were not even with a public power of attorney. We would not have been able to endorse a check. notwithstanding. It doesn't mean regardless of any of those things, you would not be able to have done that. So this is another APIA initial Friday meeting edit. And we have the ability to have that power of attorney with our insured, because what if they're out of state? What if they're out of the country? What if they're traveling for whatever reason and they can't be here to sign off on it? This gives, with a lot of limitations, it gives the authority back to the PA to be able to do that.
And for the viewers out there, the concept of signing or endorsing a check on behalf of another party, it's common law that you have to have written authorization, all right, to do so. So I'm glad that now public adjusters and public adjusting firms have the ability to do that. Just make sure the language is correct in the what we call a limited power of attorney to endorse a specific check. If you want specific language, shoot me an email, give me a phone call. I am happy to circulate a limited power of attorney for a policy holder to endorse a check on behalf.
I'm a policy hoarder. I have so many policies.
A policy holder. Oh, yeah. So
And they're
definitely make sure that the language is great and it's a limited power of attorney. I'm going to throw that out there.
I have a whole desk drawer set up with just printed out policies, just piled. I'm literally a policy hoarder because they're all messed up. There's no organization whatsoever to them. That's just my hard copies. I have to dig through it every time I'm looking for something.
Hey, and also, honestly, this has just popped in my head to prevent road stops throughout a claim and process with a policyholder and client is maybe have that language in your initial contract and have it as a whole different section where they have to sign off on it. And then it gives you that authority going forward. I think that's a good idea.
If you can make it a separate page, I always thought
Yeah,
that
no,
was a
that's
good
exactly,
idea,
that's
too.
what I was trying to say. Instead of every time you get a check, you have to send this out, get it signed and get it back.
And in this bill, as a part of that, they can revoke that power of attorney at any time in writing. So they can take back the ability for you to sign off on their checks, which is good if they're getting screwed by a PA. So good for the policyholder. Okay, then there's the financial responsibility requirements being vague, and they may impose additional financial responsibility requirements upon individuals. And if they so choose, I'll get to that question in a second. But instead of, and it says a public adjuster shall file proof of financial responsibility, it will in the Senate bill after our Tuesday morning meeting, a public adjuster may, at the commissioner's discretion, require or public adjuster may, at the commissioner's discretion, file proof of financial responsibility. So that's the new one. All right, to Richie's question. Hey, Richie. But you still can't get around the mortgage company endorsements, correct? No, probably not.
No, but
There's nothing in here about mortgage company endorsements.
But if you can get a limited power attorney from a mortgage company to sign a check, you can, right? It's the same concept, but no, you cannot not have the mortgage company endorse a check. You definitely go through those steps.
Yeah, and a lot of this is actually built into policy language. It's not in the code. This stuff for mortgages, it's more of a policy language issue than anything else. So unless that changes in the policy or possibly changes in a state mandated minimum policy requirement, such as the center fire policy or something along those lines, that won't change. All right, so record keeping. This is what you have to keep on record for at least 5 years. Name of the insured, date, location, and amount of loss. Copy of the contract between the public adjuster and the insured. Name of the insurer and the amount, expiration date, and number of each policy under which the loss is covered. Itemized statement of the recoveries by the insured from the sources known to the public adjuster. Total compensation received for the adjustment. Your compensation, by the way. An itemized statement of the disbursements made by the licensee holders from recoveries received on behalf of the insured. Any disbursements be made to third parties on behalf of the insured. Records required to be kept in this code. They have to be kept in the state, but it can be digital. So if it's accessible online, that qualifies if you happen to be an out-of-state company doing business in Georgia. I feel like we skipped something specific, though, about the insured's name has to be on any draft that is written from insurance proceeds, even if it goes into an escrow account first. If there is another check being written out of that, the insured's name has to be on that draft. And all insurance proceeds have to have the insured's name on the draft. So even the money coming from the insurance carrier has to have the insured's name on the draft, and it has to go to the insured. So if there is a vendor that the insurance company is using, then the insurance company can't direct pay to their third-party vendor. The money has to go to the policyholder with that vendor's name on it and the policyholder's name on it. So that gives the power back to the policyholder over that third-party contractor that's usually being told what to do by the insurance carrier. So this is huge for policyholders. I think that that is a really good thing. Policyholders, especially in mitigation, remediation world, if a third party is used, if the preferred vendor from the insurance carrier gets involved, a lot of times they just do their job after an authorization form is signed off on, not a contract. And then they're paid by the insurance company, and the insured is left a lot of times with a really bad job having been done, possibly in a worse situation than they would have been before. Maybe the remediation company didn't do things correctly, didn't do it to, that's right, it is huge, didn't do it to the IICRC standards, and now there's mold all over the house. If the insurance company had paid that company directly, now the insured has nothing that they can hold back until they do the job right. But with this bill, they can. So there are some consumer protections in this that are actually really cool. This is for you. I know the answer, though, if you need it.
Honestly, I don't think it necessarily changes anything in regards to AOBs in Georgia.
It does.
You think it does?
Oh, yeah. No, let me find it.
The assignment of benefits for a contractor to actually step in the shoes of the policyholder itself. I thought you were talking about specifically the policyholder having to be named on the check. I don't think that kills AO. I don't think it,
No, that's
quote
a
unquote
different
kills
it's
AOB.
a different section.
And that's what I thought Joshua was talking about.
It is a different section.
Typically, the insurance carrier wants to put the insured on the AOB anyway, regardless if you're in Florida, Georgia, or any other state. That's how I've seen it. Sometimes you can have them removed, but a lot of times you'll have the contractor and the actual policyholder named on that check. Also, a lot of times when the release comes, they want the actual policyholder, homeowner, commercial building owner to sign the release as well and have it executed on the settlement. There's one thing in regards to holding the records for 5 years. It's after the claim is resolved. From that date forward, you must hold the records for 5 years. I think that the department actually grabbed this from attorney restrictions because we have to keep records for a extended amount of years. But big picture on this bill, I feel as if they pulled different regulations and restrictions from different states, whether it be Florida or Texas, and mixed that with some attorney restrictions. And this is what was drafted. I really do think, because I can see elements from different states as well as attorney restrictions. Matt?
We're going to get to that language in a few sections. So I'm going to come back to that. All right, Josh?
But I don't think a policyholder being named on the check kills AOBs. I just don't see how that kills AOBs.
It wasn't that section.
Okay.
There was another section that specified. I don't think I skipped it. I don't think I passed it. So I think we're coming up to it. So let me just get to it naturally. And if we end up getting to the end of this thing without that, can you discuss changes if any where contractors will be able to not to act as a PA if disclosing the PA contract? We are getting to that last on purpose. Facebook user. Mostly because that is probably the biggest topic that most of you guys are watching for. So I promise I will get there. Where's Brian? Who's?
No idea. We don't have any advertisements that say Brian.
I don't know.
What's the question?
Have we had a Brian on the show?
I don't think so.
I don't know. There was some language in here that said that all funds received as claim proceeds by an adjuster acting as a PA are received and held by such adjuster in a fiduciary capacity. meaning that you're holding the funds that are somebody else's money under your care. That's a fiduciary capacity. Such adjuster shall not divert or appropriate fiduciary funds received or held. We got them to change that to misappropriate so that a public adjuster could remove their fees from that account. Otherwise, if it was you couldn't appropriate funds, you would never be able to receive your own funds out of that. You'd have to give it all to the insured, and then they would have to then write you a check. By changing this to misappropriate, which will be in the Senate bill supposedly, that fixed a lot of those issues.
Number 7 is the advertisements.
Oh yeah, let's get into this one. All right, so here's a big section. And this one's going to affect me quite a bit. All advertisements made by public adjusters shall be approved by the insurance commissioner's office before you can use it. All advertisements. We used TikTok as an example in the meeting with the Department of Insurance. How do you get a TikTok video approved prior to using it? The way the program is designed, you pretty much have to build it into the thing right away. And the idea isn't that they don't want to see the video. They want to see roughly what your content is. So from what I gathered in this, they want to know what your TikTok channel is about, what kind of things you say. The advertisement language specifies that you can't swindle insureds into filing frivolous claims. You can't misrepresent things that make them believe that they have a claim when they don't, misrepresent things that make them believe they have coverages when they don't, that kind of thing. So that was the purpose of this. Apparently there were some PAs doing some interesting things regarding advertisements, but this will affect every type of advertisement. It definitely is a very broad net, and it will have to be sent to the commissioner's office. Now he was telling us that they currently, or at least they used to approve the advertisements for a different segment of the market, and it was really, really quick. So they're just looking for keywords to see if you're saying anything specific that could, I don't know, convince someone that they have a claim before you even investigate. Because part of this bill is you cannot act as a PA or get a public adjuster contract, or you can't do anything as a public adjuster without having a public adjuster contract. But you can investigate. You can see if there is a claim before having that contract, but you cannot tell someone that they have that in an advertisement because you haven't investigated yet to determine if there is a claim or if there is coverage. So that is something that is going to have to happen. They did not define the word advertisement. They will define that in the regulations. And I know that that's going to be something that, because we do this, we're on an advertisement right now. Because we do this, I have to send them something about this. How could I do that if I'm sending them something about every single show that I put on? How could I be spontaneous with a live feed on something if I have to get that done? So we need to know what the definition of advertisement is. And the Department of Insurance has agreed to work with us on that in the regulations, but it needs to be broad in the meantime so that he can narrow it down in the regulations. If it's too narrow in the statutes, then it really handcuffs them when trying to create something in the regulations. So that's the idea behind it.
And in the meantime, just put on your thinking cap as a reasonable person, what's an advertisement and what's not. You know what an advertisement is. So just think about what is and what's not, and what needs to be approved by the DOI and what does not.
You also can't have a company, the guy that just texted me, remind me of this. You cannot have a company logo that looks like a government agency logo or might be misconstrued as something a government agency might use as their logo, because you don't want to misrepresent that you are acting on behalf of a government entity. So if you have a business entity that has a logo that could be construed as governmental, or maybe a shield of some kind, something along those lines, probably something you want to consider changing before this becomes a law.
And can we put up Joshua's question real quick? Does that advertisement provision fail the Central Hudson test? What the Central Hudson test is if any type of restriction on commercial advertisement violates your First Amendment right to freedom of speech. And Joshua, just for some context, in my opinion, it does not fail the Hudson test, so to speak, because this is a restriction. I'm a licensed attorney in the state of Florida. They pulled this from the state of Florida and the attorneys and the restrictions on the attorneys in that state and implemented it on PAs in the state of Georgia. We have to abide by the same thing. And I promise you, it was fought, and it was not considered a infraction of the First Amendment right.
No, Chad, that's probably not going to fly.
Claim a cop. And the same thing, attorneys can't have some type of government shield or emblem on their type of advertisements as well. It's the same thing,
But you
same
all have those
restrictions.
balancing things in your logos and stuff.
Those are scales, and we can
Well,
have
doesn't-
scales.
Doesn't holding a legal pad make you some kind of an authority? Whoa. Our green screen is awesome. Okay.
the things that intrigue
pretty
Matt.
cool. I almost wanted to put it up in front of me to see if you can see my face through it, but I know that won't work. But I wanted to. That's how stupid I am. Okay. Where are we at? So advertisements. Now, written advertisements is defined in this, and written advertisements shall also have specific language on it. Let me find written advertisements. For the purposes of this subsection, the term written advertisements includes newspapers, magazines, flyers, and bulk mailers. The following disclaimer shall be bold in text, all capitalized, and you have to write this in your written advertisements. And it still has to get approved by the commissioner's office before you can use it. But it has to say, this is a solicitation for business. If you have had a claim for an insured property loss or damage, and you are satisfied with the payment by your insurer, you may disregard this advertisement.
That's okay. I mean, honestly, if that's what they want to have in there, all caps, put it. It's just more text. It's maybe a little bit more money for that advertisement, but at the end of the day,
It's not going to hurt,
it's not
make or
gonna kill
break
you.
anybody here. And so it's not a big deal. It's just surprising.
It is.
It,
But
I want to
Hey,
believe the average consumer.
at the end of the
would have been
day,
able to
you
figure it out.
can actually solicit business,
Yeah.
rather an attorney cannot.
That's true.
You know,
We can
Hey,
solicit.
that is true.
Yeah. Take
Hey,
that, attorneys.
We can't do that.
We got you there. All right. So now solicitation requirements have become a little bit more stringent. In the previous law, you could not solicit during a loss producing event. And that was exactly how it was worded. Now that's still there, but now it's also, you cannot solicit during a loss producing natural disaster occurrence. I don't think it deletes the original language, but it definitely adds in during a natural disaster occurrence. I don't know why that is not considered an event from the previous one, but and then they define natural disaster. And then there are hours that you can solicit. If someone calls you not during these hours, that's okay, but you cannot cold call someone during those hours. Does that make sense? So the hours were set to 9 to 9 p.m., 9 a.m. to 9 p.m. weekdays and Saturday, and then noon to 10 p.m. on Sundays. And in the Senate bill, something that GAPIA and APIA were able to do is extend that just slightly. So 8 a.m. to 10 p.m. will be on the Senate bill, and 12 to 10 p.m. on Sunday. So we're going from 9 to 9 to 8 to 10. We extended 1 hour both ways, except for on Sunday. It still starts at noon, but between noon and 10.
So guys, don't call policyholders at midnight trying to get business. That's what it's trying to say at the end of the day.
Yeah. The word during is not in this. I said during because it's easier for me to describe that. So, all right. All right. This language was removed in our Tuesday meeting. That changes things quite a bit. So let me read you what the language was. And you can think about it. An adjuster shall not permit an employee or agent in the employee's or agent's own name to advertise, solicit, or engage clients, furnish reports, or present bills to clients, or in any manner conduct business for which a license is required under this chapter, unless such employee or agent is so duly licensed. This would have required everybody that does anything for you as a public adjuster to be a licensed public adjuster, including sending an invoice, sending out some kind of a advertisement of some kind, a solicitation, cold calling your clients, engaging your clients, giving an update would have required a public adjuster license. So we got them to remove in the employee's or agent's own name to advertise, solicit, or engage clients, furnish reports, or present bills to clients. So now it reads, and it'll be this way in the Senate bill, an adjuster shall not permit an employee or agent to engage in any manner of, well, how would it read? An adjuster shall not permit an employee or agent or in any manner conduct business for which a license is required under this chapter unless such employee or agent is so duly licensed. So it just says that your employees, if they're doing something that requires a license, they also have to be licensed. Which
Nothing's
is
changed.
self-explanatory. That's nothing new.
Nothing's changed.
But by removing that section that we got them to remove, takes away that issue.
If you're going to interpret policy or negotiate a claim, have a license. That's pretty much what it's saying.
There's specific language in here that says that you cannot adjust losses for health insurance, bodily injury, third-party stuff. It originally said that you could only act on first-party property claims, which pretty much said the same thing as before.
Right.
All right. Here's the big section. An adjuster shall not participate directly or indirectly in the reconstruction, repair, or restoration of damaged property that is the subject of a claim adjusted by such adjuster. Here it is, guys. If you are a public adjuster and also a contractor, this would eliminate you from acting as a contractor on the same claim that you were acting as a public adjuster on, because there is a fairly known conflict of interest there. And there's very few states that allow this as a result. So this is, no, it doesn't open the door for auto, Josh. It says, it actually specifies auto in here. I just didn't read it. Or accident insurance policies. Yeah, it doesn't open the door for auto. You don't want to do auto. Bodily injury policy or any claim for which a client is not insured under the insurance policy. It still has the language for first party property losses, and it still specifies in the regs that you can't do auto. So I don't think it does, but I suppose it could maybe. Honestly, I'll have to look back at the previous section, Josh. Maybe you're not so far off after all.
I'm sure some regulations
Yeah.
further down the road are going to 100% address that.
So you cannot participate as a public adjuster directly or indirectly in the reconstruction, repair, or restoration. You cannot accept kickbacks from contractors for referrals. You cannot acquire an interest in the salvage of the property without the insured's express written permission. You cannot represent an insured on a claim or charge a fee to an insured while representing the insurance carrier at the same time. So you can't do both sides of the field. You cannot directly or indirectly solicit employment for an attorney or enter into a contract with an insured for the primary purpose of referring an insured to an attorney. So it's saying you can't act as a runner for an attorney. You cannot act on behalf of an attorney during the course of a claim adjustment through an insured signed attorney representation agreement or other means. Basically, you can't get hired as a attorney's. Does this keep you from acting as an expert? Act on behalf of an attorney during the course of a claim adjustment. So no, you can't act on behalf of the attorney while you are acting as the public adjuster is what this is.
Yeah.
If it's in litigation, that changes the rule. An adjuster does not engage in misrepresentation to solicit a contract or agreement to adjust a claim. I'm going to go back up to a section I just skipped. An adjuster shall not engage in any other activities that may reasonably be construed as presenting a conflict of interest, including soliciting or accepting any remuneration from, having a financial interest in, or deriving any direct or indirect financial benefit from any salvage firm, repair firm, construction firm, or other firm that obtains business in connection with any claim the adjuster has a contract or agreement to adjust. So this is the section that basically separates any conflict of interest between a public adjuster and a contractor. We have been explained a lot about this section. We asked very specific questions to the attorney of the commissioner. I flat out asked him, if a contractor were to pay the public adjuster's fees on behalf of an insured, would that be a conflict of interest? And they said, no, it would not be a conflict of interest. So as broad as this statement is, they want to, in the regulations, narrow down what is or isn't a conflict of interest. So they have promised that we will have a seat at the table to really work on this section is the one that I was a little bit the most nervous about because of the way that I gain business. I work with contractors quite often. Now, I'm not also a contractor. I haven't adjusted a claim that I'm acting as a contractor on as well. But very often the insured doesn't have the ability to pay for a public adjuster. So the contractor, in an effort to help the insured, in an effort to get the claim moving, often pay fees on behalf of an insured for a public adjuster. It happens all the time. And that's a huge benefit to policyholders, especially in a state that doesn't have any real dispute resolution available. So the commissioner's direct attorney did specify, when I asked him directly, if a contractor covers the public adjuster's fees on behalf of the insured, is that a conflict of interest between the public adjuster and the contractor? And he said no. Now, if the public adjuster collects a fee on top of their normal rate, maybe an additional kickback or something along those lines, then there is a conflict of interest. So that's kind of where he drew the line.
And Chad specifically asked that. He really wants to know what's the definition of a kickback, really, right?
The contractor pays my PA fee. I do not charge the homeowner a PA fee. Is that a kickback? Well, you are charging the homeowner the PA fee, but the contractor is covering your fee on behalf of the insured. So
a kickback would be additional funds on top of your percentage.
you need to adjust the way that you're
There's a
looking
kickback.
at how you're doing this. That's all it is. So the contractor isn't paying your fee. The contractor is covering this cost that the insured has on behalf of the insured. You, as a public adjuster, have to work to the best interest of the insured alone, only the insured. If you are acting to the interest of a third party, another contractor, then there is a conflict of interest. Now, a conflict of interest exists when there's a conflict. If the insured's interests align with the contractor's interests, there's no conflict, right? So until there is a conflict of interest, there isn't a conflict of interest. I don't know how else to explain it. It's scary language, but it's going to be worked on in regulations. They promise us to see the table to do so. As a contractor, you are absorbing the fee. It becomes an expense for the contractor.
So the contractor's taking a hit on profit.
Thanks, Boris. Yeah. So as long as the contractor is paying on behalf of the insured. Now, if the insured cancels the contract with that contractor, then they're not going to pay the fee on behalf of the insured anymore, obviously. And you cannot, as a public adjuster, require them to use a specific contractor. And that's true today with our current language. If you are acting as a public adjuster and a contractor on the same claim in the state of Georgia, which is currently legal, the public adjuster contract cannot require that the policyholder use your contracting firm. It has to specify that you will act as a public adjuster to their best interests, regardless of whether they use your contracting firm. You can provide the benefit currently of covering the public adjuster's fee if they use your contracting firm, but you cannot require them to. So this just further specifies what can be done. So with this bill, assuming it becomes law, You will not be able to act as a contractor with a direct or indirect interest in a contracting firm if you are also the public adjuster on that claim. However, you could, as a contractor, cover the costs of the public adjuster on behalf of the insured as a benefit to the insured as a contractor. But if your interests ever don't align with the insured, then the public adjuster has to go with the policyholder's interest. And that's true now anyway. I tell contractors that work with me all the time, if you're going to refer a claim to me, you should know up front that if your interests ever don't align with the insured's, I have to, by law, look out for the best interest of the insured. I appreciate the referral, but I have to look out for their interest. I'm legally obligated to. I will lose my license if I don't. And this just really clarifies a lot of that, and will be even more clarified in regulatory changes. I know that there was other specific instances that were brought up to the commissioner, whether or not if there's a public adjuster that is married to a contractor, can that public adjuster work on the claim that that their husband or wife as the contractor is also working on? That is not a conflict of interest, according to the commissioner's office. So that was a big deal for somebody that I know. So there's definitely a lot that needs to be further clarified, but they have agreed to help us clarify those things in the regulations.
We will have a seat at the table.
Yes, so that's the idea. All right, so I'm going to move from that section, and then we'll come back, and I know you're going to have some more questions. So
We're almost finished. And Matt, I'll piggyback off of what you say and I agree with what the Department of Insurance is saying, that there is not a conflict if, let's say, the wife is a contractor and the husband is a PA. I mean, at that point, what the DOI is trying to dictate what profession a husband and wife can actually go forward with. Like, it didn't make sense, but I'm glad the DOI saw that as well.
Okay, here's a section that regards contractors. So all of you that are contractors, listen up. A contractor shall not act as a public adjuster or advertise to adjust claims for any property for which the contractor is providing or may provide contracting services, regardless of whether the contractor holds a license under this chapter or is authorized to act on behalf of the insured under a power of attorney or other agreement. There's that AOB language. Other agreement, read AOB. Regardless of whether the contractor is authorized to act on behalf of the insured under a power of attorney or other agreement. So just because you have an assignment of benefits doesn't mean that you can act as a public adjuster. And that's where that language that removes AOB stuff. You can still have an assignment of benefits legally in the state of Georgia. And these are painful for some reason. I think someone bent them. So that's where we're at with that. Now, in that Tuesday meeting, we were able to get them to add some language to this thing. And it was kind of a off-the-cuff, last-minute thing I threw in there, hoping that they would do this because I think it will make contractors feel better by putting a black and white line. There's less gray area. So this is language that I pulled from Florida's regulations, propose it to the DOI, and supposedly it's going to be in the Senate bill. And it immediately follows that last line that I just said. However, a contractor may discuss or explain a bid for construction or repair of covered property with a residential property who has suffered the loss or damage covered by a property insurance policy or the insurer of such property, if the contractor is doing so for the usual and customary fees applicable to the work to be performed as stated in the contract between the contractor and the insured. This is language that came from Florida. And it was important that we did it that way because most of the new language that's in this bill actually came from either Florida or Texas. The Department of Insurance pulled that language from those to try to update it with and modernize the code when they wrote this. So this came from Florida's language. The benefit here is that if you are a contractor, the insurance company cannot say that they don't have to talk to you. They will have to discuss or explain your bid with you. So the last thing we want to do is remove the ability for a contractor to present their bid and their estimate to an insurance carrier. And none of this law did that. And none of this removed it. But we all know that insurance companies will interpret it the way that they're going to interpret it. And this solidifies the fact that you would be able to discuss your bid. So hopefully having that black and white line codified will be helpful. I think it will. I hope it does.
It should.
We really don't want to hurt policyholders with language like this just by changing some of the language in there. So that was something that we got added in.
If you think about it, Matt,
That was only
if you can't have your selected contractor to submit a bid, I mean, policyholders will just be going with preferred vendors all the time. I mean,
Yeah.
It makes sense.
Yeah. So this is good language that was added in there. And then the rest of this is pretty standard stuff. You know, they can withdraw your license if you act against the new regulations and impose additional requirements on you if you are found to be acting in a manner that isn't consistent with this code, or demonstrating incompetence or untrustworthiness. So that's what we have. And this is our bill. Right now it has passed the House and it is in a transition period. So once it goes through crossover, where all the bills that originated in the House are passed and move over to become a Senate bill, where they will be debated and then voted on in the Senate. And all the bills that originated in the Senate that have passed move over to become a House bill to be debated and voted on in the House. That's called crossover. That happens all at once when all of these in the House that are done, once they're done with all those, and then all the Senate ones are done, then they exchange hands basically. That way they don't start getting mixed up in the House with House originated bills and Senate originated bills. At crossover, basically anything that didn't get out of the House that originated there is stuck in the House. This did make it out of the House, and it is waiting for crossover where it will become a Senate bill. Or another person on this show said it will be Senate Bill 254. I don't know if that's true, but he would probably know. So good source of information. Hopefully that is what it is, and it's a little bit easier. So first week, at the latest mid-March, we should see this thing pop up in the Senate, and then it's going to end up at the Senate Insurance Committee. And that's where it will be looked over a little bit harder, and there will probably be a lot more meetings, and there's going to be a lot more work on this. Probably it isn't done. We have what's the word I want to use?
Made tremendous strides.
We've made tremendous strides on this. Now, yes. Now we have agreed with the changes that we were able to make. We have agreed with the language of the bill as GAPIA. If any major changes happen, that could change. But this, in its current form, considering all the things going against us, it being very, very fast, suddenly dropped, and then within a week going through the subcommittee. Once it's out of that getting the language changed was a very, very unlikely endeavor. Doing that from a bill that was written by the Department of Insurance, sponsored by the chair of the House Insurance Commissioner's Office. The fact that anything has been changed on this is ridiculous. So everybody that's been involved in this has done a tremendous job of working with that. There is a lot of things that will need to be regulatory issues, and GAPIA will be working with the Department of Insurance to make those regulatory languages, which is great. Ultimately, this does provide some protection for policyholders from bad actors in our profession. And we don't want bad actors in our profession because it makes us all look bad. So, all right. So let's start taking some questions. Is it a conflict of interest?
Let me answer this as well, because I've been contacted by many contractors, many public adjusters. When will this come into effect? When do we have to start making these actual changes itself? And just to let everybody know, they will give us a heads up on when these changes will be implemented. There will be a hard deadline, and it will be, for instance, in the state of Florida, the AOB legislation that went through, they said, look, this is what's coming, but we're going to give you a couple months heads up. And on July 1st of 2019, going forward after that date, you must implement all of these restrictions with this actual bill itself. So you will get that heads up. As of right now, it's not like you have to go run and change your contract and send it into the DOI tomorrow. There will be a hard deadline.
I want to point out what Chad posted here because this is something that I want to make sure that everybody is aware. You know, GAPIA did accept the language of this bill, but it's not because we hate contractors. That's most of us, actually, a large portion of our membership is also contractors because it's legal in Georgia to be a contractor and a public adjuster on the same claim currently. This changes that, but the vast majority of our members that are also contractors also agree that there is a conflict of interest there. So none of them are really fighting against it, or at least that portion of it possibly. But by adding this language in about what a contractor can do, I hope that expresses the fact that we're not enemies, contractors and PAs. And it's often that we are portrayed that way. And I don't want that to be the case at all. Not in this state. Not in this state.
I love contractors.
We work so well together. There is such a good business relationship between contractors, relationship between contractors and PAs to the benefit of the policyholder. Without that relationship, the policyholder isn't in as good a position. So we want contractors in the state to be able to be effective. And even if you're using a public adjuster, the fact that you'd be able to discuss your bid as the contractor still helps a public adjuster quite a bit. So this is good for every party all around. So I'm glad you brought that up, Chad. Thank you.
Absolutely. And look, the contractor is the one doing the work. They should be able to talk about the numbers in the bid.
It's their bid. Of course.
I mean, I hire contractors on a regular basis as my expert in testifying to what needs to be done and how much it's going to cost, because they're the ones that are doing the work and buying the material and paying for the labor. It just makes sense.
I'm not a contractor. You're not a contractor.
No, not.
We often have to write estimates as if we know what the heck we're talking about as public adjusters. And a lot of us do. I think I do for the most part, but I'm not always right. And when I am in over my head on something, I get a contractor involved to help me with the estimate. But ultimately, if the contractor doesn't accept the estimate that I agree to, then it's not accepted because the contractor has to be able to do the work for that amount. And it's their bid that matters more than mine. I'm just writing a rough estimate, like a scope, so that the insurance carrier can put a certain amount of money aside as a reserve. That's what my estimate's really for. If the contractor happens to agree with my estimate, then it works out really cleanly. But anyway, all right, so let's get to the questions. Is it a conflict of interest if the licensed PA who works for a contractor does not charge a fee for adjusting if the service is free?
My first take on this is it's a conflict of interest when the insured is not put first, right? When the intention of the PA is more towards helping out the contractor than it is the insured. I can tell you this. I think there's no white and black on that question, so to speak. And I think maybe the regulations might more specifically address some of this. But if the insured is not injured, I think that's what the DOI made it clear to us. That's when there's a conflict.
There has to be a conflict when the interests don't align. When the interests don't align, that's when there's a conflict. If the interests align, there's no conflict of interest. That's how he described it. He literally said it like that. And I clarified to him. We spent probably half an hour on that one section. It was a couple-hour meeting. It was honestly very much like dealing with an insurance adjuster. I hope he didn't hear me say that. Greg, you're way better than dealing with an insurance adjuster if you're watching this. I like you a lot better than most insurance adjusters that I deal with. and I like a lot of insurance adjusters though. I need to start backtracking. I'm going to get my foot out of my mouth. I'm going to just shut up. At least you have communication with your DOI. We were able to only meet twice with our director in Illinois on behalf of public adjusters in Illinois. Keep up the good work on behalf of PAs in your state. Hope they appreciate it.
Matt, I think you'll agree to this, that the DOI, Greg, when we wanted to meet, they met.
They did. They did. Even with the miscommunication where they thought they had already agreed to stuff with us. And then we came to the table with a list of issues. I can only imagine that he assumed we were messing with him. But he still came to the table, and we still were able to get past that. And we even laughed about it at the end, that there was definitely a miscommunication. So we do have a decent relationship, or at least a budding one. We had the similar thing going on before COVID hit. We were already possibly working with the Department of Insurance in Georgia on the regulatory changes. I had rewritten one of the code sections I was planning on getting GAPIA to agree to vote on, and then we were going to present that to them. But COVID hit, and it kind of put a damper on a lot of that. So we hadn't really talked to the department, not in a face-to-face official stance since then. But Greg had come in, he presented to GAPIA at one of our events. We do conferences twice a year for continuing education and networking and all that fun stuff. And Greg Connolly came and talked to us. And honestly, it was right after our actual insurance commissioner, the one that was elected, was indicted for insurance fraud. And then Commissioner King was appointed the office from the governor. So they came in feeling like their department had some egg on its face and wanted some help to clean it up. They wanted to clean up the image. And to be honest, we've had a lot of not great insurance commissioners. So I was very happy that they are willing to work with us. Is repair of the house, i.e. rebuilding, considering the same as mitigation, such as tarps, trees, drying? Are those mitigating guys who are not rebuilding per se considered contractors?
I'm going to say
Yeah.
yes.
Yeah, I think so.
I'm going to say yes.
Because they're contracted to perform work on a property.
Right.
Yeah, that's it. That's a yes. So you guys have any more questions? We are an hour and a half into this 1 hour show.
Not
But-
for the first time.
No, that happens every
No.
To be honest, we might as well just make it an hour and a half show.
Says the hat. Olivia.
Pat, stop talking.
She keeps us straight over here. She really does. But it was an important topic, and it needed to go an hour and a half. This needed to be discussed. We need to go through the bill and then hit the highlights.
Once the bill is received back from the Senate, do you anticipate a contractor and public adjuster will no longer be able to be one and the same? Is the loophole around the new law to put the entity into an individual's name who is not a part of the contracting company? There's not any loopholes. Don't look for a loophole. That's part of the problem. All right. It either is or it isn't illegal. So once there is if this does become law, and it probably will, you won't be able to be an adjuster and a contractor on the same claim.
No, that is, when talking with the DOI, that is definitely one of their whole agenda behind this bill. You cannot be a contractor and a PA on the same claim. As we all know right now, you can if it's on the front page of the contract and the policyholder signs off on it. Whenever this does pass and it's enforced, you cannot be a contractor and PA on the same claim.
Can an assignment of benefits hire a PA or be the same? No, that's part of the new language.
I don't know.
I'll read it again. So a contractor shall not act as a public adjuster or advertise to adjust claims for any property for which the contractor is providing or may provide contracting services, regardless of whether the contractor is authorized to act on behalf of the insured under a power of attorney or other agreement. I think that other agreement would apply to assignment of benefits. So if it does apply to assignment of benefits, then a contractor shall not act as a public adjuster, even with the assignment of benefits. So what does the assignment of benefits give you the authority to do? Can you act as the policyholder?
You step in the shoes as the policyholder.
But only if the insurance company allows it in writing, right? That's what the policy's saying.
Yeah, I disagree with that, but it does. The policy does say that. There's a difference between stepping in. I don't want to go down the AOB route because there's a difference between stepping into a claim and stepping into the policy. Okay, there's two differences because the risk changes itself. But can the AOB hire a PA? I think this language where an individual, a contractor, has an AOB executed and they can't act as a PA forces them to hire a PA.
Now, the adjuster, the public adjuster, cannot be hired by anyone other than the insured. So unless the assignment of benefits turns the contractor into an insured, maybe it does. I don't know.
Yeah, the whole concept of an AOB is that the AOB holder steps into the shoes of the policyholder. However, in the state of Georgia, I highly recommend not doing AOBs because it's somewhat of a dying aspect of insurance in the state of Georgia right now.
There's a lot of conflict there between insurance carriers and public adjusters that are hired under an assignment of benefits. So it's not the best situation to put a PA in. And they're already working an uphill battle in this state. You know, this is a really tough state to work in. We don't have any realistic dispute resolution. So the appraisal provision is broken because of bad case law. We don't have arbitration mediation. That's just not in this state. Attorney's fees don't get paid without bad faith 3 years down the road after you win a breach of contract or something along those lines. And then it gets tacked on. There's no private cause of action against the unfair claim settlement practices. There's no time frames set by the code for how long the insurance carrier has to do something on a claim or even to respond on a claim for property losses that aren't arising out of auto policies. So there's a lot that makes this an uphill battle in Georgia. Adding in that additional conflict probably isn't in anybody's best interest, not the policyholders, not the contractors. Generally speaking, you're probably not going to get very far with that.
Hey, Jason Friday, I do appreciate it, bud. Thank you.
Jason Friday. I know a Jason Monday.
I know Jason Friday. He's a great guy.
Is that his real name?
Yes, it
Because
certainly
I literally
is.
know a Jason Monday.
Well, there's a Jason Friday. There we go.
Wow.
Jason Monday.
I wonder if they
should be
know
friends.
each other.
What's that?
They should be friends.
They should be friends.
Should they? I think Friday should hate Monday.
I think Monday should hate Friday.
Whose side are you on? Friday is way better than Monday.
I appreciate it, Jason. Thank you, bud.
Yeah. So the takeaway here is I think I'm going to wrap this up because it sounds like there is the questions are slowing down. This has a long way to go. We definitely have a possible roller coaster ahead of us. When it hits the Senate, the language can change on a whim. Somebody could get an earmark put in, things like that. So this is something that we are keeping a very close tabs on. We have lobbyists engaged that is keeping his ear to the ground to make sure that nothing crazy happens. But if it does, we'll be there to work on that, and we'll keep you guys informed on what's going on as often as we can. Right now, we're kind of in a breather, and probably nothing new will occur until mid-March-ish. But we'll try to do this again then to keep everybody informed. In the meantime, there are organizations that are working this in the state that are in need of funds to help fund the efforts that we're doing. GAPI is one of those. We could definitely use some additional funds to help pay for our lobbying efforts. If you wanted to go to gapia.org, there is a link to donate funds there. I know that AAA, the American Adjuster Association, has been working pretty heavily in Georgia as well about this bill. And I know that they're also looking for new members and things. If you are a public adjuster that is currently licensed in Georgia or thinking about becoming a public adjuster in Georgia, GAPIA would love to have you as a member. We do plan on helping any public adjusters that currently work for or are also a contractor on trying to help transition into strictly working as a PA, if you need some help on how to go about doing that, we want to be able to provide as much help there as possible so that so policyholders don't end up taking any of the brunt of the change, because anytime there's change, it's always a little bit difficult.
Right.
So
Guys, and the sky isn't falling. You know, it's changes, and worked with the DOI, and here we are. And the industry will be moving forward.
Yep. So Georgia's looking to update itself on the codes, the statutes and regulations. So anyway, we appreciate your time today. Next week on Tuesday at 4 p.m.
We have Stephanie Lee.
Stephanie Lee. So she's also on the nomination for Best PA, along with myself, TJ Ware, and Jack Hanks.
There might be some friction next week.
There could be.
Could be some friction here.
Could be. We
I'll
may get in a
mediate.
debate. Who knows?
I think she's going to obliterate you.
She might just
Ooh.
destroy me.
Ooh, from
She
the
just
hat.
I will tell you this: she is winning that race right now. So if you don't want that to happen, if you are a fan of Matt, please go vote for me, because I really want to rub it in with her when she's on the show. If you could do that for me, that'd be great. You have until next Tuesday.
I'm sorry. I may have to back her because, women run the world.
It's true.
Isn't there a
We
song
do.
like that?
I don't think
We
my wife
run the
controls
world.
me.
Thanks, everybody. Hey,
All
if you have any questions, reach out to Matt or I. We're here to help out. If you want specific language for your contracts to implement these new regulations, don't hesitate to contact me. I'm here to provide that information, and so is Matt or anybody else on the board of GAPIA. Thank you so much. I
I'd be happy
appreciate
to
it.
help. All right. Thanks, guys. Take care.